So I'd like to talk a little bit more about the importance of early intervention, early management of a dispute so that you can get to early resolution and get it off your back and back to what you're normally doing. So that really begs the question of, when do you take action? When do you realize that you need to take some action so that the dispute doesn't continue to fester, continue to worsen, get aggravated, and eventually escalate so that it becomes a much more difficult dispute to deal with? Well, really, some of that is just common sense and self-evident. If you're paying attention to what's going on in your business and with the people that you do contracts with, I think you'll know when a dispute is starting to happen, because there'll be tensions rising, there'll be communications becoming more difficult, people will be starting to assert things to each other. That's when a dispute is coming into existence. And I'll talk about this separately about the importance of how you can assist yourself in these areas by particular clauses you can put into your business contracts. But the critical thing here is intervene quickly. Now, if you intervene initially yourself and you have a particular set of procedures and methods to do that, and hopefully ones that you can incorporate into your contracts, you'll already have a head start. You can pursue, obviously, your own negotiations to the point where you think they are working, to the point where you think it's helping you dissipate the dispute and bring you back and the other party back on track in a harmonious way. But if you can see that's not happening and it's continuing to aggravate, you need to call in someone to help you. I want to give you some examples of how this works in practice from real situations. So obviously the first step when a dispute's starting to happen is to try to resolve it yourself. Unfortunately for many people who are not trained in this area, you tend to do and say things that often exacerbate and aggravate the dispute, and that usually happens through deterioration in communications and language. When people's emotions start rising, they say things that don't help, starts to polarize the people in dispute, and before you know it, they're rushing off to their lawyers for advice. What we try to encourage in the way we work is to try to nip these things in the bud. And one area that I can give you a good example of where we've done a lot of testing of our particular approach is in residential building disputes. So what happens there, and you can see why this is a wonderful illustration to use, is that someone's just bought their biggest investment probably in their lifetime. It could be their dream home or some very special renovations. They spent a lot of time in thinking about and planning for it, and now they have a builder who's they're in contract with, and they're watching the house being built or the renovations being done, and they start to see things they don't like. And they start to get concerned. They raise it with the builder. They don't feel the builder is paying attention or responding appropriately. Tempers start to rise, and allegations are then being made by the owners to the builder that they're not doing their work properly, that their work is defective, that the contract's not on time. They're now being exposed to extra costs that they weren't anticipated, and so on. The builder, hearing these things, often responds in a very defensive way, and sometimes quite aggressively, which is along the lines of, look, I know what I'm doing. Can you just get off site? Let me finish my job. I've got other work to move on to. You're holding me back. You're just getting in the way. You got the makings of a dispute right there and then. Now this is, at these points of time, what is critical is the parties' awareness that they can do something about this before it gets out of control. And if it gets out of control, the contract will start to collapse, and sooner or later one party or the other will rush off to a lawyer, demands will be made, and the case will spill into court or into the Consumer Trader and Tenancy Tribunal residential home building division. And that's where your dispute will go for the next 12 or 18 months and rack up a huge amount of legal costs. There's an alternative. There always is an alternative. There always is a better way. Here's a scenario to think about. The owners and the builder together become aware of an early management, early resolution service. They call in a trained person. The trained person comes in and hears what the owners have to say, understands where their angst is coming from, why they're frustrated, why they're angry, and they speak to the builder and they understand and get from the builder what's going on for him. They start to manage that communication in a way that keeps people in the fold, if you like, because the conversation is managed in a polite, courteous way, and the expert who's working them makes it clear that they're not taking sides, but they're there to work with the two of them to try to understand as quickly as possible what are the critical issues happening here, and then setting up a process to deal with each of them. So let's just take one example. The contract hasn't completed yet. The owners are pointing to a whole lot of things which they're saying are unsatisfactory work, defective work, or incomplete work. And the builder is saying, well, those things are going to be fixed up at the end. There's a point of time to deal with those things at the end of the contract, and it's in the contract. So you don't need to sweat about it right now. The owners say, but no, you're asking us for more money right now. You're asking us to pay the next installment in the contract, and we don't want to pay that money until these things are fixed up to our satisfaction. The builder says, but the contract covers all this. And the contract says, I'm entitled to this next installment of money now. And if you've got these problems that are picked up later, there's a time to deal with them. That's the standoff. This is the sort of thing that can stall a contract and kill it in its tracks right then and there and spill the matter into court or into the tribunal. So what happens then if you bring in a service like ours? You bring in some external expertise to deal with it. It's actually very, very simple. The person obviously would take account of what the contract says. They would hear both sides of the dispute, and they would set up what the issues are about this defective work, incomplete work, the timing of installments, and so on. Once they've done that, if there are any technical issues here about contract compliance, let's say, this is a technical issue. So instead of the matter spilling into court straight away, it can be dealt with in a very simple, common sense way. And it's using a particular type of ADR, alternative dispute resolution, called neutral expert opinion, neutral expert determination. Why wait 12 months or 18 months to have a court hear your different experts speak about this issue when you can agree on a neutral expert, highly regarded in this area right now, bring that expert in and give them a list of these issues, what each side says about them, and say, tell us what you think. Because this is exactly what's going to happen in any event months down the track if the matter is litigated. The parties can do these things off their own bat, by their own decision, and say, wouldn't it be better, this is the commercial side of it, wouldn't it be better for both of us now to tone down our emotions, to work together, and this is where on the way we work, it's based on cooperation, on collaboration and creative thinking to come up with solutions and options to resolve these issues that underpin the dispute quickly, nip them in the bud, get them out of the way, and get the parties to move on with their contract. It's these tension points based on a clash of perspectives, a clash of viewpoints, and each side is hot under the collar, but they're not able to communicate properly with each other. They're not able to properly explain themselves to each other. The reason why they're clashing is that each of them sees things differently and thinks differently, has a different viewpoint. You need someone to come in who can recognize that and then start to get a more effective communication going on where matters that do need to be dealt with now can be dealt with, and matters that can be deferred or which in fact are non-critical issues can be got off the table and out of the way. So in those instances, and I can say to you that in doing this many, many times over, by working in this cooperative and collaborative and creative way in the residential building area, as one example, disputes that have burgeoned and got out of control, stalled the contract, so the person's house now is stalled where it is, no more work is being done, tools have been downed, parties are spilling into court now, and everything is held up now for the next 12 months or more, and heaps of money being spent on both sides to their respective legal teams. That's a nightmare. And this nightmare is a regular thing in litigation in this area. If those same people could be introduced to a different way where they could say, does that make sense? Is this really what we want to do? Or would we rather try now to cool down and have someone come in and help us resolve this quickly now at low cost and get the matter back on track? Isn't that what we would prefer? Well, 9 out of 10 people will say yes to that. In some minor percent of cases, someone will say, there's a need for this to be litigated for some reason. And there may be. There may be need for a particular precedent in a particular case. It may be that the personalities are so difficult between people in dispute that even a trained person might say, throw their hands up and say, well, you two really just have to sort this out in court. But they are the very, very minor percentage of these disputes. So that's one example where residential disputes can be resolved within weeks. Very low cost compared to that alternative scenario of falling into litigation. Partnership disputes, joint venture disputes are no different. People start off with the dream. They start off with the project. They all got in on board together to do something that's important, that's going to benefit them both. This is the way many business dreams begin. People come together with a great idea. They then work out how they're going to take that idea and turn it into reality, and they know that to do that, they have to work with others. That's why you have joint ventures. But it can go bad. And it can go bad for many, many reasons. It can go bad because the contract wasn't well drafted, and now there's misunderstandings, there's ambiguities, there's differences of views about how the contract works. It can be personality clashes. It can be that certain things that were anticipated that would be done and done by a certain stage can't be done for various reasons that weren't foreseen and weren't anticipated. And in many cases, maybe timing isn't a very important issue. So these things, this is just reality in the commercial world. But when those things happen, again, the choice is stark. Do you want the whole thing to stop so the business dream gets stalled while the parties go to their lawyers and go into court to have some judge months down the track or years down the track decide this case for them? Or do they want to nip it in the bud now? And again, 9 out of 10 will say they want to nip it in the bud if they can. They'll take on board what their potential legal rights are and what might be involved to vindicate those legal rights. But the most important thing for the commercial person, the commercial enterprise, the business owner, the joint venture partners, is to get that dispute resolved quickly and, if at all costs, avoid litigation. Now, let me just tell you, if you have a partnership dispute, millions of dollars can be involved, both presently and into the future. And a partnership dispute that spills into the Supreme Court is a very, very nasty situation. And in most cases, it spells the end of that business venture. So the odds are very high. Now, if one of those partners or a number of them is aware that there's a way now of working quickly on the problem and can get everyone on board to do that. What I'm talking about here is premised almost all the time on the willingness to work cooperatively. In order to take these disputes, nip them in the bud early and resolve them early, it is premised on a number of things, and it's important that you understand that. People in dispute are in dispute because they can basically no longer talk to each other properly. They've become polarized. It's at that point that they throw up their hands and say, I've had enough, I'm going off to my lawyer. Now that, if it happens, gets to that point, and you're not aware that there's an alternative way of addressing it, which is the way that we do it, if you can bring your dispute to us, then the writing's already on the wall. You know, you're heading into litigation, and you might as well get ready for it. But if you can understand that there is this better way, it's available to you all the time. You just have to pick up the phone, make a call, and say, we're at this point now, tell us what we need to do. So let me just tell you very simply, because I've done a number of these partners disputes, let me just walk you through it very, very simply. One of the distressed partners calls us, says, this is what's happening. We say, come on in. We don't charge you to find out about your problem. We don't charge you to find out what the nature of the dispute is. We don't charge you at all until you've entered into a retainer with us, and we only allow you to do that once we can say to you and the other people in dispute, we understand this dispute, and we can see how we can help you, and we can draw up a blueprint and a protocol to deal with it, and we can, if you participate in good faith with intention to work together creatively to resolve this, that we can get this out of the way very quickly for you and at minimum expense. But how does it happen? Well, it takes two to tango, right? It takes the people in the dispute to say, let's do this, but often it's initiated by one of those people. One finds the service, whether it's us or someone else, and they come over and we have our session. Our session is to understand how you see the dispute and understand the history of the dispute. Second step is we say we need to talk to the others in the same way because you're in dispute. We don't become your legal representative. We want to be treated as a neutral service to help you in the dispute resolve it quickly. So the others have to also exercise that opportunity to come in and talk to us. When that has happened and everyone's satisfied by what they've heard and the questions they've asked and what we've answered is that we can do something for you and they want to go that way rather than litigate, we're ready to do business. And when we're ready to do business, we present an agreement to you that everyone who's involved in a dispute will sign and say that you're appointing us and you want us to basically implement the blueprint that we discussed with you. We draw up that agreement, you sign it, the blueprint is fully spelt out in the agreement, all the terms in terms of what the issues are that we're going to do, the steps we're going to go through, the costs involved, how those costs will be shared between you, it's all spelled out in that agreement. Once that happens, everything's signed, we get to work. So what I want you to take away from this segment is to recognize when you've reached that critical point that, to put it simply, you're stuck and you're not able to advance things yourself. That's the point of time that you should put your hand up and say, we need to get help here, otherwise this dispute's going to get out of control, and before we know it, we're going to be in court somewhere. Second thing is who to go to. Well, I'm speaking to you and explaining to you how we do things at the Commercial Dispute Management Center. It's as simple as picking up the phone and calling us, visiting our website, calling us or sending us an email, and arranging the initial conference, which is free of charge. It's as simple as that. Everything else then just flows from what occurs in our first meeting where we explain things to you and you get to ask all the questions that you want to ask.